Okay, if we're ready, then we'll begin. Welcome to today's MedTech Bridge presentation. The first portion of today's program focuses on key FDA regulations related to quality systems and submissions, recent enforcement trends, best practices, and pitfalls to watch out for. The second portion focuses on HIPAA privacy requirements for drug and device makers and the similarities and also the differences between HIPAA and GDPR. As always, today's presentation is being recorded and will be placed on our members only section for your future reference. We will run about 45 minutes, leaving time for Q&A and ample time for you to reach your seats at this evening's match with Belgium. Please use the chat feature on the system for your questions with Tim Christensen, monitoring these as we go. He may choose to break into the presentation or wait to the end based on the nature of the question. He'll also follow up after the presentation with any questions left unanswered. Today's presenting firm, Twin Cities-based Gardner Law, focuses exclusively on the medical, technology, pharmaceutical, and biotechnology industries, and the wide range of legal and regulatory counsel clients in this space require. Your presenters today are Gardner Law attorneys Amanda Johnson, Bryn Stanley, and Paul Rothermel. Amanda Johnson specializes in FDA law, regulatory submissions and strategy, compliance programs, and fraud and abuse laws. Her corporate experience includes roles at Coloplast, United Healthcare, and Medtronic. Bryn Stanley has a similar specialization, along with a deep expertise in quality systems compliance and remediation. Her corporate experience includes roles at Boston Scientific, St. Jude Medical, American Medical Systems, Covidien Medtronic, and most recently, Monteris Medical. Paul Rothermel specializes in privacy and cybersecurity, including HIPAA and GDPR, and other state and international laws, as well as healthcare compliance matters. He has extensive additional experiences in the area of privacy and security in both the public and private arenas, including Medtronic and the state of Minnesota. Their complete bios can be found on the invitation to this webinar, as well as on their website, gardnerlaw.com. With that, I will turn it over to Amanda Johnson. Amanda?
Thanks, Dave. Appreciate the introduction. We're actually going to have Bryn start with discussing quality systems topics. But yeah, just wanted to reiterate Dave's comments. Thank you for joining. We appreciate you joining. This will be an interesting topic, and please feel free to interrupt or ask questions as we go along. Here's the agenda. As Dave mentioned, we're going to be talking about FDA quality system regulation, overviews of requirements, best practices, as well as FDA submissions. I'll touch on US compliance requirements, and then Paul will discuss HIPAA privacy requirements and also kind of comparing and contrasting to GDPR requirements. And with that, I will hand it over to Bryn.
Oh, my thing was not unmuting for a second. I've had a panic. I'm okay now. Thanks, Amanda. So I just wanted to kind of touch on sort of just a broad overview of the quality system regulation for the FDA. This just shows kind of all the different sections that it covers, organized into kind of 9 quality system areas. And you want to flip to the next one?
Yep.
And it's very similar if you're familiar with the ISO standard 13485. So basically the quality system regulation, similar to 1345, kind of covers all aspects of the business, from kind of supplier controls to management requirements to production. So it's not just, specific to a product type necessarily, but more to focused on kind of how the business is being run. So this comparison that I have here to the 1345 standard is sort of highlighting some of the, if you already have compliance with the ISO 1345, this is sort of highlighting some of the differences where the quality system regulation is lacking, where 1345 already has that, sorry, it's the other way around. This is the additional requirements that you would have to add onto a 1345 compliant quality management system in order to be also compliant with the FDA's quality system regulation. So kind of the first piece, and this was one of the bigger changes for 1345 for 2016, is the risk-based approach for everything in the quality management system, not just, product risk. And that is not specified at all in the quality system regulation, but it is something that the FDA looks for and is expecting as part of your quality system, as part of the quality system regulation. It's detailed out more in kind of FDA guidances and not necessarily in the regulation itself, but it is something that, if you have 1345, you should be okay as far as meeting that. But it is just something to kind of watch out for, because it's not as directly stated in the quality system regulation. So the next one then is the quality system regulation has a very specific requirement for an independent reviewer. The ISO 1345 standard does have requirements around representatives of functions concerned with the design, specialist personnel, but that's just something to watch out for. If you have a 1345 compliant quality management system, you'll want to make sure that you kind of update that to include independent reviewer also required. The terminology in the quality system regulation versus the standard is different. For the most part, it's like the example I have here for the design history file versus the design and development file. They're gonna have they're essentially equivalent sets of documents, but it's just the FDA quality system regulation is very specific to calling out things such as the design history file, that you'll want to at least kind of update your records and your documents to make sure that you have those specific references called out. The other kind of main piece then is for the quality system regulation, it only calls out product software and risk once within the design control section. And then sort of similar to the risk-based approach in the first bullet here, it is the expectation with the FDA that you will kind of comply with essentially the way that the software and risk is detailed out in the 1345 regulation. So there's like I said, when I was talking through the first bullet, there's a lot of kind of patchwork guidances that the FDA has kind of put together to sort of emphasize their thinking on it. But the quality system regulation essentially has remained unchanged since its implementation in 1997. So it does have it is a little bit kind of, I guess, behind what some of the more international standards are for quality systems. So that's why there's kind of it's a little bit more difficult to kind of piece together everything to make sure that you're kind of meeting the expectations of the FDA without just isolating yourself kind of on that quality system regulation. There are some other differences as well, but if you do have a 1345 compliant quality management system, examples are something like customer property. There's nothing in the regulation that discuss kind of how a firm needs to handle customer property, and that's something that's included in the 1345 standard. But if you are compliant with that already, there's nothing additional that you would need to kind of put in place to be also compliant with the quality system regulation. So if you want to go to the next slide. So the FDA has been kind of working then to harmonize themselves a little bit better with the 1345 standard for quality systems. So they originally had proposed the rule in May of 2018. It's been kind of put on the back burner, taken on and off on hold, but it now has been listed again in the spring of 2021 at the proposed rule stage. And then you can see in the abstract that I have here, which I won't read word for word, but essentially the FDA is intending, and they haven't kind of, this rule has obviously not been released yet. So it's sort of a little bit of a mystery, I guess, exactly how they're planning on kind of changing the quality system regulation or harmonizing with the standard. But the intent here is the FDA, they're trying to make it a little bit more streamlined for both, you know, US based businesses and as well as international businesses to kind of be able to sell products in the US and meet that standard. And the FDA does view the 1345 standard as sort of the gold standard as far as quality management systems. And they have had a hand in they've had a hand in developing, you know, those changes to that standard that have come out throughout the years. So it's their expectation, or it's their view that that standard is, you know, where they want to be in the future state. So kind of this is just something to kind of watch out for. The transition period will likely be a few years still, and there will be kind of a lot of work within the FDA to change all their documentation and IT systems and everything like that, just to kind of align with this. But that's just something coming down the pipeline to kind of watch out for. But in the meantime, you will still need to have, you know, compliance with the quality system regulation as it's written today. So if you want to go to the next. So, okay, so these are just some kind of quality management system kind of considerations. So the FDA doesn't, there's not like we come in and for most products, they don't come in and inspect and say, yep, your quality system is up to snuff and we're ready for you to sell products. There's sort of an honor system for compliance for a lot of different types of products. So it's important kind of as you're even doing the product development process to start implementing a QSR compliant quality management system. So as I have there, it's sort of an honor system, but you will want to make sure that as soon as, you know, any product hits the market, that you have that in place and there's no risk there. And then the quality management system, or the quality system regulation for the FDA, the intent there is to help build out documentation that's required for the FDA submissions. So as far as kind of design control process and everything like that, I think you will want to make sure that you have kind of at least those baseline quality management system procedures in place as you're doing that product development, because it just helps the submission process go smoother and make sure that you're not, you know, getting a lot of those questions back. And Amanda will kind of talk about that a little bit later, because the FDA can start and stop the clock. And if you have kind of this stuff done in the first place, then it will help some of that go a little bit smoother. Another thing that you would want to do is just make sure that you're performing mock audits against the quality system regulation to make sure that you know, like I said, have kind of everything in place. And the quality system regulation, similar to 1345, does require to do internal audits. I would suggest, I guess, in this case, if you don't have internal auditors with kind of the quality system regulation background, that you would want to kind of, you know, maybe find a third party to perform mock audits on your quality management system before even maybe doing the submission. It would help kind of greatly, like I said, kind of reduce some of those timelines. And then kind of the final and bigger piece that I think gets overlooked a lot is just make sure that your quality management system is tailored to meet the needs of your organization. So there's the quality system regulation, you know, is high level, and it's important to make sure that, you know, you are meeting obviously the quality system regulation itself, but then you're meeting your internal procedures that you've implemented to show that you've met that quality system regulation. So some organizations like having those very prescriptive procedures in place internally, so that they, you know, their employees can kind of look for them and make sure that they're following them every single step. But then there's kind of the downside to that is if it's too prescriptive, then you may end up with compliance concerns where you're not following your own internal procedures that maybe aren't even required for the quality system regulation. So audits can help with some of that. If you find, you know, that you're not meeting certain requirements that you've placed on yourself internally, that maybe it's not really necessarily specific to the quality system regulation, that maybe is a sign that you want to back off and change some of your procedures. But there's no kind of right or wrong answer for that, but it's just kind of a watch out to make sure that when you're kind of, as you're, you know, building out your quality management system, that you're making sure that you're not tripping yourself up unnecessarily or kind of painting yourself into a corner. So if you want to go to the next slide. So kind of tying, hand in hand with the quality management system is you're going to need to have, there's registration and listing requirements for all establishments kind of that are involved with the manufacturing of medical devices. And then there's a series of slides that we're going to go through later that we don't need to necessarily go through in detail, but they are kind of listing all of, it's not just, specific to manufacturing. There's a lot of different activities where that facility will need to register and list. The whole reason for this registration and listing process for the FDA is that they would like to know where these devices are made and kind of key processes happen for these devices in order to prepare and respond to public health emergencies. And then I just have the 2021 fees for registration, and that's an annual fee that just needs to get paid for all the establishments that are involved or that are required to register. And like I said, so these are, there's going to be a series of slides that kind of say exactly kind of who needs to register, who needs to list, and then who needs to pay that fee. And the kind of the key ones I want to point out here are things like contract manufacturers. I think on the next slide, it has the initial importers. So foreign establishments are going to have an initial importer. And then we'll talk about this a little bit on additional slides, but I just want to make sure that everybody's kind of aware that those are entities that are also going to need to comply with the quality system regulation. And so the kind of main manufacturer will have to have their quality system compliant with the quality system regulation. And then any of these other services, activities that they're involved with, whether they be domestic or foreign, there's, and then if you want to flip to the next couple of slides just to kind of look here. So this is some additional examples, I guess, of domestic establishments that would need to have those, and then these foreign establishments. So whether if you're using contract manufacturers that are foreign, or if you're using contract manufacturers that are from the US, they are all going to have QSR compliant quality management systems. And then it's ultimately the responsibility of the main manufacturer to make sure that their service providers are meeting those requirements. So the FDA will come and potentially inspect all of these contract manufacturers, not just the main manufacturer or the main entity that is selling the device. So I think there's one more slide on foreign establishments. And then if you want to flip to the next slide. So this is the second bullet here. I jumped ahead a little bit, but any entity that's required to register is also going to need to have that QSR compliant QMS. So you'll have to make sure that you have a quality agreement that you have signed with any of your suppliers or external vendors that kind of parses out who does what for each of those for each of the 29 sections of the QSR that we had shown at the beginning. So and like I said here, the manufacturer is ultimately responsible for ensuring that their suppliers and certified service providers are meeting their FDA requirements. So before you kind of take on anybody, as any of those kind of entities listed above in the previous slides, any kind of contract manufacturer, anybody that's providing sterilization, anybody that's acting as like a labeler, you'll want to make sure that you do an inspection before taking on that supplier, and have a quality agreement signed with them to make sure that you have your roles and responsibilities for the QSR assigned to your organization. And additionally, making sure that they are taking care of the other types of services that they are providing. So if they are acting as a contract manufacturer, then any type of like process validation, any of their supplier controls, those types of things, you'll want to make sure that they are following the quality system regulation, in addition to those roles that you're taking on, which may be something like a specification developer, or that type of, or an over labeler. So it's you just need to make sure that all those different parts are doled out appropriately. And then kind of the first bullet here is that registration and listing, and this is where we sort of talked a little bit about sort of that honor system. There's not necessarily going to be an FDA inspection before the device gets released on the market. So you will want to make sure, though, that as you've done your registration and listing, that you're not in any way making that appear as some type of approval, clearance, or authorization of the facility or device. That can be considered misbranding, and Amanda will talk about misbranding a little bit in some of her slides, but that's just something that there's a lot of companies that will say, you know, I'm an FDA registered facility, and that's a big no. So just don't end up doing that. So registration is just, it's part of the process, but it's not something that denotes any kind of authorization from the FDA. And then just kind of a final other consideration is that there are requirements, and it's a separate process that you'll have to go through for unique device identification with the FDA. So those types, that process, you want to make sure that you get that kind of started early also, because that is required as part of the registration and listing process, and that is something that will need to happen before any products can go on the market. And so then the next kind of order of business, as a foreign organization, if they want to sell products in the US, is they're going to need a US agent. It's part of the registration process that we just spoke to. And then the US agent will complete a process to confirm that they've acted to agree as a US agent. And then kind of the bare minimum requirements of the US agent is that they cannot use a post office box, they cannot use an answering service, and they must have somebody available to answer the phone during normal business hours. And they must have a U.S. residence or a place of business in the United States. And then this goes through sort of the responsibilities of a U.S. agent. They are involved in kind of any communication with the FDA. It's more of a kind of an administrative role. They help in, assigning inspections, responding to questions, and then there are certain circumstances where the FDA may provide information directly to the U.S. agent and perhaps not provide it to the U.S. agent first in instances where they cannot get to the foreign establishment directly. Or, and then just another consideration to make sure that you're aware of is that if they are providing that information to the U.S. agent, it's equivalent to providing it to the foreign establishment. So you want to make sure that you're choosing a U.S. agent that you're, comfortable with and trust, that they will make sure that they understand their roles and responsibilities, and that, they are going to provide that information to the foreign establishment, as soon as they can, because it is an important role, but like I said, it's more of an administrative role. That last bullet kind of points that out. So there's other kind of regulatory requirements that the U.S. agent does not have responsibility for. So if you want to flip to the next slide. So this is just sort of a consideration. There's, like we discussed, there's the initial importer, and there's a U.S. agent. So the U.S. agent is an administrative role. The initial importer, they will have responsibilities for things like medical device reporting. So you just want to make sure that you're not kind of confusing the two and that you're signing those quality agreements with your initial importer to kind of dole out those regulatory responsibilities. Whereas with your U.S. agent, you may have sort of a different type of contract set up with them just to make sure that they are fulfilling their administrative roles, but they won't have the regulatory responsibilities detailed out in those contracts. The U.S. agent may also act as an official correspondent. That's not a requirement. The foreign establishment can have an official correspondent that resides outside of the U.S. or has the place of business outside of the U.S. But occasionally that is seen as a dual role. It's just an option to consider. So I think that was it for the quality piece. So I'll let Amanda for FDA.
Thanks, Bryn. That was a good overview. Appreciate it. So we talked a little bit already about quality system requirements. So kind of some of the boxes to check before you would enter the US market is, building a quality system that complies with FDA's quality system regulation, registering and listing, and then kind of the big piece that everyone thinks about when they're thinking of going to market is the submission piece. So of course we have to, figure out whether we need to get FDA approval or FDA clearance before we get to the market. And so I'm going to kind of walk through some key regulations, key rules, some best practices, and we'll go into some kind of pitfalls and things to watch out for. So you have a product, you're designing a product. I would encourage you early on in the process to complete step one, which is figure out how your device is classified. And this is something that you want to actually put some time and thought into. You can't get this wrong. So FDA has 3 different device classifications, and they're risk-based: class 1, class 2, class 3. It doesn't always align with the EU classification. So, sometimes there will be a difference. And also I think EU's is flipped. So it's the risk classifications are flipped. But there are 1,800 plus. They're always adding more types of devices that have associated classification regulations. So you want to make sure that you do your homework on the front end so that you really understand how your device is classified, what requirements apply to your device. And of course, this will tell you what submission type you have to use as well. So I just put some resources on here. So their FDA has a product classification database. I encourage you to use that. It's not super user-friendly, but you type in kind of the name of the device, the generic name, and you can kind of search through and figure out where your device best fits. FDA does have a formal submission process for classification. So if you really are unsure, and maybe you had a second opinion and you're still not sure and you want to be 100% confident, you can submit something called a 513G request for information. Basically, you submit to the FDA, describe your device, and they will provide a response and tell you how they believe it will be classified. And one kind of not maybe commonly known, the FDA has a division of industry consumer education called DICE. They do have an email address, and you can send in kind of informal questions about device classification. I've actually had really good luck getting responses from them. They sometimes will call you back and have a discussion. But I just wanted to share that resource as, the role of this division is to interact with industry and really educate industry and kind of be the go-between to help them understand how to get to market. So just wanted to put that out there. And this is just an example of FDA's product classification database. You can see, so if you go in there and search glove, there's, I think, 10 different types of gloves, but here's an example of a patient exam glove. It'll tell you the product code, which would be important for a 510K submission. It tells you the submission type, and then it also tells you kind of the regulation number. So these are all important for, of course, submission. And then down here, you'll see, is the product exempt from GMPs? It's not. So that's good manufacturing practices. And then another important piece to look is down here if there's any consensus standards that apply. And not all devices will have standards listed here, but it's important to check and see if you have any there that you need to address. All right, so step 2. So, okay, let's say you have your device, you're sure of your regulatory classification. Now it's time to prepare the submission. And this is assuming that you have, gone through the quality management system and you have your design history file created. Submission type, and it's important not to get this wrong. And as long as you're sure about the classification, like we showed on the last page, they will essentially tell you what product or what submission type is required. So I just put some examples up here. Some class 1 devices will be 510K exempt, which means you don't actually have to submit anything. That doesn't excuse you from like the quality management system requirements, and a lot of the times they'll still, GMPs will still be required. There's the 510K submission, which I think seems to be the most popular. There's a de novo submission, which is if you have a kind of moderate risk device that does not have a predicate. So if it's a very novel device, for example, or you can't find a similar product that's already on the market, you can submit a de novo application. And then for the class 3, and I think there's some class 2 devices, the route would be a pre-market approval, which is called a PMA. And that has a little higher threshold of evidence required, usually requires clinical studies. And then I just put on here investigational device exemption. So in some cases, you may need to submit an IDE application before you conduct a clinical study. So that's for investigational products. That would be before you submit a PMA. And then there's also something called a humanitarian device exemption, HDE. This is for rare diseases. All right, so I just want to just briefly touch on kind of the 510K process, just because this seems to be kind of the biggest bucket of submissions. So mainly class 2 devices, a few class 1s. And really, this submission type is interesting because you're demonstrating in the submission that your device is as safe and effective as another device that's already on the market. So you have to select a predicate device and then demonstrate in the submission that they are substantially equivalent. So there is kind of that comparison quality, which is interesting, and kind of something that a lot of people don't really think about, but that's a big part of what the 510K process is. And there can be some differences. I'll talk about it on the next slide. For a 510K, the standard kind of review time for the FDA is 90 days. So once you submit, FDA has 90 days to review. Bryn noted, and this is common, but essentially the FDA can stop the clock if they have questions or if there's deficiencies. So it often does take longer than 90 days. Just wanted to note that. And that's one of the reasons why we always want to make sure we submit a complete and comprehensive submission to, prevent those types of time delays. And then it's always important to see or to check with the FDA website to see if there are any guidance documents that apply to your device type. So FDA has certain special controls guidance, and they're actually really helpful. And so if I ever find a device that has one, I'm like, yes, it tells you kind of exactly what FDA expects. And so those special controls guidance are really important when building your submission to make sure that you're submitting everything that FDA expects to see. So substantial equivalence, just quickly, this is when you're demonstrating that your device is equivalent to a predicate device, which is already on the market and has already been cleared by the FDA. So you're essentially saying that it either has the same technological characteristics or there may be different technological characteristics, but you're submitting data that demonstrates that those differences aren't going to raise any different questions of safety and effectiveness. And this is kind of an art, I'd say. It's not so much a science. It's important to have a good risk management file when you're making the substantial equivalent argument. So just wanted to point that out as well. And then just submission considerations. So, design controls obviously are important. That a lot of the documents created in the design through the design control project or portion of the project will be submitted to the FDA in the 510K. There's bench testing, performance testing. You'll have to submit verification and validation test reports. If there's any kind of patient contact, there should be a biocompatibility assessment and potentially test reports. Clinical evidence. So, most 510Ks don't require clinical evidence, but if you're looking, there are some that may, and de novos and PMAs typically will require clinical evidence. Bryn mentioned labelings. So these are all just things that you'll have to consider before you submit. So you do have to submit draft labeling in the 510K or in the PMA. And there will be some level of kind of back and forth with FDA on the labeling if they have, if they have questions or issues. But you'll want to put forth, a good solid draft of the labeling that takes into account the FDA regulations. And then I just put some tools and resources. So just, want to make sure that you use everything that's out there. FDA has done a good job really of putting out guidance documents. They do webinars. They have training modules on their website. So if you have questions, there are kind of a lot of resources out there. FDA also has the Q submission program, which a lot of you may think of as the pre-sub program. So if you have questions about your submission, about your, regulatory questions about the strategy. If you have, questions about the clinical study, FDA does encourage you to use the pre-sub program. And a lot of people shy away from that just because it does, it's another few months added into the timeline. But really, I've seen a lot, it actually results in time savings in a lot of cases if you go in to the FDA with a submission that they don't, maybe they don't agree with the clinical testing or, the testing strategy, that they would end up, losing time during that process. So it is something that you should consider and maybe used as appropriate. And then FDA also has the breakthrough device program that you may want to consider if you have something that's, new and novel. The breakthrough device program is not a market approval or market authorization submission, but you submit it before your 510K or before your PMA. And if they kind of approve you as a breakthrough device, there are additional kind of resources and you're, fast tracked, quote unquote, when it comes to submitting the actual market authorization submission. So just something to consider. So step 3, okay, we've had our, we've created our submission, it's complete, it's comprehensive, it includes everything that FDA would expect to see. So now we come to the submission process. So there are user fees associated with submissions. I put the website on here. There is a small business program and foreign establishments can apply. It takes a little longer because it has to go through the foreign country tax authority and then to the FDA. But the small business program, if you get approved, you get reduced user fees. So it is something to consider. And in some cases, it's a pretty big savings. So something to think about. E-copy. So in order to actually submit to FDA, so a lot of people think that you just, can email or, electronically submit your 510K. And so unfortunately, it's a little more complicated than that. FDA has an e-copy requirement. So submissions actually have to be submitted in electronic copy on either a CD, DVD, or flash drive. And there's certain technical requirements for that. FDA has a variety of tools that can be used that you can actually download from their website to create those e-copies, but they have to be in a certain format. And I put on here, it can be burdensome. So it can be tricky. I just would caution not to wait until the last minute to figure out how to create these e-copies. Better yet, if you can find someone who knows how to do them. I do them and they're still tricky every single time. But yeah, just wanted to point out that it's not as easy as one would think in terms of submission. And then once you submit it, so you're successful at creating your e-copy, you validated your e-copy, and you actually have to send it in a envelope to FDA. It'll go through an administrative review. So during this review, they'll check the e-copy, make sure that it meets the requirements. They will make sure that your submission contains all of the kind of content chunks that it should have. During the administrative review, they're not looking at the content per se. They're looking at, do you have the required pieces so that we can review it? So once it passes the administrative review, it goes into the interactive review. And this is where you may get questions from FDA. There may be some back and forth. And I'll talk a little bit about kind of how to handle that back and forth. But ultimately, then, you'll get approval, clearance, or hopefully approval or clearance, or potentially, a not approvable letter or an approvable letter, non-approval or non-substantial equivalent. So these are just some reminders. So, once you're on the market, there are FDA rules that still apply. And I just want to kind of remind everybody of those. So, of course, you can't promote off-label. You can't promote products for unapproved or new uses before you get clearance or approval from the FDA. You can't, so if you don't have approval or clearance, you can't make claims or imply that the device is safe or effective for that investigational use. And then once it's cleared or approved, you can only make claims, and claims are kind of defined broadly, that are accurate, truthful, and not misleading. There's a fair and balanced requirement when it comes to talking about risks and benefits. All the claims have to be supported by substantial evidence or clinical experience. And I talked about off-label already. And just making sure that there's an internal process in place to review all the material before it goes out. So FDA expects legal, regulatory, and medical professionals to review and approve promotional materials. So just quickly, what happens if FDA regulations are not followed? So these misbranding and adulteration are kind of the two regulatory hooks, so to speak, that FDA uses to enforce the Food, Drug, and Cosmetic Act. So misbranding, that occurs, or that is triggered if something is wrong with the words used to describe or promote the device. So as we talked about on the last page, if we're making claims that are improper, if you're providing false, misleading, unbalanced information. And then adulteration is generally triggered when something is wrong with the way the product is made. So this is referring more to manufacturing issues, or if the company has an inadequate or non-compliant quality management system. And then I won't go through each of these. These are just kind of the enforcement tools that FDA has to enforce the Food, Drug, and Cosmetic Act. So once they, determine that either a product is misbranded or adulterated or both, they have really a wide range of enforcement tools in their belt that they can use. So, everything from a warning letter to seizure to, prosecuting, civil monetary penalties. There's criminal prosecution, consent decree. So just to give you an idea of kind of the broad range of enforcement mechanisms that FDA has. So best practices, kind of in summary, I just want to, reiterate the importance of really getting the classification and submission type right the first time. That will, if you get that wrong, you're kind of that throws off the rest of your path. And get a second opinion if needed. A lot of people will have, a consultant or a firm perform a reg assessment and have it documented internally so that they have that on file in case in case FDA does question it. Make sure you're picking the right predicate. There's kind of an art to that as well. It'd be best to get somebody who has experience with these submissions to help evaluate predicates and make sure that that's the correct one. If you need to use the Q submission process and submit a pre-sub, feel free to do so. It may save time and cost in the end. Kind of the most important one is really making sure that you're actually reading and following FDA guidance. So FDA puts out these guidance documents and they have a repository on their website. And I just want to, highlight that it really is important to read and follow those because FDA will expect you to follow them. And if you deviate, provide an explanation as to why what you're providing does not comply or does not align with FDA guidance. Kind of along those same lines, when you're preparing the submission, it's never a good strategy to make FDA ask for something that they expected to see in the original submission. That will just cause delays. It may annoy the reviewer, and it's always best to just put everything in the initial submission and try not to, unless it's part of a strategy, which happens sometimes, but anticipate what they want to see and provide it in the submission. Find somebody who knows how to do e-copies in advance. Don't save that to the last minute. It does take time. And really just, kind of a high level, but try to view FDA as a partner. Be collaborative. Don't be on the defensive when you're working with them. The reviewers are all really great people. They're all smart, usually biomedical engineers. They are just trying to help in terms of, their job is to review the submission, work with the various cross-functional partners at FDA. So I just want to, point that out that, there is a point where you can, escalate issues that come up with the reviewer, but generally I've had really good experience with reviewers. And, in the end, it helps to build those relationships and try to, maintain that collaborative relationship with FDA. And I think this is the last slide, just things to watch out for. And I already mentioned a lot of these, but failing to submit the documentation that FDA expects, that's going to cause delays. If you provide inadequate documentation or testing, that is going to cause delays because they're probably going to come back and ask you either to repeat testing or provide different documentation. If FDA comes to you during the interactive review process with questions or deficiencies, get back to them quickly, and they'll usually ask for, they'll usually, when they send the request or questions, they'll say, hey, get back to me by X date. And so just try as best as you can to keep that communication line open and really respond to them in a timely manner. That will keep the relationship, keep building the relationship, but also keeps the time delays to a minimum. Again, the e-copy process, can you tell that the e-copy process has been a pain point for me? And then just planning for ongoing regulatory support. So once you get kind of approval or clearance, there's continuing regulatory obligations. So anytime you make a change to a product, you're going to have to do an assessment to determine whether you need to submit again. And there's just going to be ongoing, topics that you'll need regulatory support for. Don't rush submissions. And that seems to be just a common thing just with projects. Even at big companies, small companies, the submission is always like the finish line, it feels like, and it gets rushed. I totally understand the timing and the criticality of getting things in on time and for investors and for deadlines for the business, but just try to plan appropriate timing to actually put, the appropriate amount of attention onto the submission. Really having somebody who knows the process is really helpful rather than having somebody brand new learning the process. Just wanted to point that out as well, because again, rushing submissions will just result in, pushing the delay down during the review time. And then I'm sure a lot of you have heard there's a pandemic, but essentially there's been a lot of delays at FDA based on COVID workloads. So, I mean, unfortunately, there's not much we can do about the fact that they are, overwhelmed with work, and especially in some divisions, but we can persist. So just, keep checking in. If you're not hearing back, you can go up the chain. You can ask to speak with their supervisor, but just know that may be something that you encounter. I know I'm working on several submissions right now, and I think all of them have been delayed based on COVID delays and reprioritization. So just something to point out right now. Hopefully, I think hopefully FDA is going to be hiring people in the near future. I think I've heard that, but just for now, there are some delays. So just expect it, but also be persistent. All right, I'm going to skip over this. This is just some compliance requirements for ongoing healthcare compliance program requirements. These just get glossed over a lot, so I wanted to put in a plug. But yeah, with that, I'm going to hand it over to Paul. Paul, I'm anxious to hear a little bit about HIPAA and how it compares and contrasts with GDPR.
Thanks, Amanda.
Yeah.
Let's dive in here. Go ahead and to the next slide, and we'll talk about HIPAA in general. And I think it's helpful to know a little bit about the background of privacy in the U.S. Typically in the U.S., until the last few years with these state privacy laws, privacy has been a sectoral approach. So you'll see this list of examples, but there's privacy laws around various sectors or technologies. But there hadn't been until California and some other states started to pass these general laws, any real broad privacy laws that covered everything in terms of data. Contrasting that, just to give some context, obviously Europe and other countries, Canada, et cetera, have these broader privacy laws, that general data protection and things like that. And that's just to this point been a pretty significant difference in terms of privacy. So HIPAA specifically, of course, is primarily a healthcare privacy law. But I would want to point out that health insurance is a big aspect of HIPAA, and that drives really context to the law, why it applies to the entities that it does, and some of the nuances of the law. So it was designed originally to apply to health insurance companies, to healthcare providers that bill insurance companies, and to companies that give support to those companies. So business associates, healthcare clearinghouses, and those sorts of companies. A deeper dive into that is that it doesn't necessarily apply to all health information in the US. So for example, employers may have some health information about employees, different contexts where health information is collected. This does not necessarily implicate HIPAA. And that's a key point for medical device, med technology, pharmaceutical companies, because they, depending on their exact circumstances, may or may not be a HIPAA covered entity or a business associate of a HIPAA covered entity. So that's a key point that we discuss quite a bit with our clients. So for example, we've got on this slide a few examples of where med device companies or med technology companies could be a covered entity. Typically, that'll be an organization that offers a specific kind of technology or device that includes healthcare providing, and then on top of that, also bills electronically to insurance companies directly. So not every medical device company does that. Actually, very few, generally speaking, do. So that's a key point of differentiation there. And then also, med device companies and med tech companies tend to be business associates more commonly, particularly if they offer solutions that involve, uploading PHI, protected health information, to the cloud, or other vendor kind of supported solutions that process that information outside of just the context of, here's a device, here's how you use it at the hospital or clinic, but it's uploaded to some other location that's maybe processed by that company. Then it would be a business associate relationship generally. So from there we can move along, and I'll try to go quick so we can do some questions and so on, but want to cover some key points here. So if you are a covered entity, there's a long list of requirements. They're unlike some of the general laws that sort of give a risk-based approach to compliance. HIPAA is very prescriptive. It gives a list of must do this, must do that, and part of that is creating a set of policies and procedures. So there's not only a necessity to follow the law, but also have policy around it. Appointing privacy officers. There is no size limitation for covered entities. So if you meet the definition of a covered entity, which is again kind of rare for medical technology companies, but then if you are, you must follow these requirements. And part of that is limitation on using and disclosing PHI. You can think of that as similar to sort of the ways that GDPR and other laws allow many different uses of personal data within the context of that law. Similarly, HIPAA has this designated set of uses and disclosures. If it's not in that list, you can't use it for those purposes, but it's helpful to know that the list is long. There's a lot of different appropriate ways that PHI can be used and disclosed. So that's a key thing to note. And then also any sort of misuse of PHI, mishandling. So if it's used in a way that's not appropriate or disclosed in a way that's not appropriate, there's a reporting structure. So if you're a business associate, you report to your covered entity. If you're a covered entity, you have those direct obligations to report to government officials or potentially individuals who've been affected or the media. Beyond that, similarly to other privacy laws, HIPAA requires responding to patient requests. There's a very specific parameter of which requests are allowed or permitted or need to be responded to. They include things like access to PHI, authorizations to disclose PHI, et cetera. So if a patient wants access to PHI, they're allowed to get that, and there's time frames and requirements around that. Additionally, there's a security rule, and the HIPAA security rule is also very prescriptive. And instead of giving a general appropriate appropriate security standard, like a lot of privacy laws do, it gets into some of the details and talks about encryption specifically and other controls that are very specified. And that can be a challenge, and that's one of the bigger kind of costs to implement of HIPAA, is not only having those in place, but also doing risk assessments around that. So we'll jump to the next slide here. If you're a business associate, and this is a little bit more common, but a part of the approach to compliance is policies and procedures. It's really important for business associates to have good security controls. That's a hugely important piece. And then overall, that really the role of a business associate is to support and cooperate with the covered entity that they're working with to make sure that all of the requirements are met that usually are contractually added to that business associate. We can jump to the next slide. If you're not a business associate or not a covered entity, you aren't subject to HIPAA directly. But medtech and drug companies and device companies are very much in a sort of situation where their customers have these obligations. Therefore, there's some obligation by those other organizations to support them in that. So that may include just being aware of their obligations of the customers and being aware that if we pay you to do marketing, for example, we're causing you to violate the HIPAA privacy rule, or if we sign a business associate agreement that's not necessary, for example, that could lead to some compliance risk for our covered entities. So having those awarenesses and carefully thought out planning as a med tech company can really set up our customers for success, and then they'll appreciate that awareness and support. So quickly to compare, a really significant aspect is what it applies to in terms of data. And obviously the EU has a broad General Data Protection Act that covers everything. And again, HIPAA is focused on these specific entities and how they operate. Another key part here is how you can avoid kind of being under the regulation through whether it's anonymization or de-identification. HIPAA allows a very clear de-identification safe harbor. So if you follow these parameters and these requirements, you're no longer subject to HIPAA in terms of processing that set of data. Obviously, GDPR has a more complex and difficult structure on that front. Both of these laws have a sort of controller processor set up so that there's always a chain of trust or a set of contracts that apply throughout the chain of processing of any information subject to the law. So that's a similarity, and I won't dwell on that too long just for the sake of time. Penalties, both of these laws have pretty significant potential penalties. You can see in HIPAA, there's a long history of enforcement going back 10 years or so to when the HITECH Act was passed. And that really drives down into an emphasis on data security in general. So a lot of these are driven by data breaches or security rule failures, whether it's by a covered entity or a business associate. You'll see the penalties here per violation. That's really a small number compared to what usually comes out because these are per violation, and each violation is maybe a single misuse or single disclosure of a record of PHI. So if you have 100,000 records or something of that nature, you can see how these numbers can skyrocket. So a lot of times the companies that get into these enforcement actions are settling and agreeing to pay millions if they get into that situation, just to avoid the potential of multi-million to $10-20 million plus settlements or litigation. So from that's a really quick recap. I think I blazed through that, but we'll open it up for questions if we have a little time here.
Yeah, that sounds good. Thanks everybody for a very interesting introduction to both claims and regulations around FDA. We have some questions, and I know we are actually out of time, but there are some pressing questions here around, and that may be even both for you, Bryn and Amanda. So I'm just going to say all of the questions, and maybe you can comment on them. So if the FDA has decided a device is so low risk that they have decided to use enforcement discretion, how does the manufacturer go about this? And does that mean the device is also a 510K exempt, or would they need to file a 513G to get the exempt? And in case you are not under oversight, does that also mean you don't need to have a QSR? And what about inspections? Can you still expect? I know that was a lot. One question, but
yeah, there's a lot to unpack there. And I don't know if we have time to get into it all the way, but I kind of think of where software is a medical device. They have some areas for general wellness devices that they exercise enforcement discretion on, whether they qualify as a medical device or not. So it really is kind of the typical lawyer answer. It depends. We'd have to look at the product, figure out whether it actually meets that enforcement discretion, and then whether it actually is a medical device that's exempt from 510K requirements, or if it's not regulated as a medical device at all. And if it's not regulated as a medical device, then FDA regulations would not apply. I don't know, Bryn, if you have anything to add in terms from a quality perspective.
No, that's a pretty good summary. I mean, if it is regulated as a medical device, you will need to be compliant with the quality system regulation. If it's not, then yeah, the FDA requirements won't apply.
Yeah, I'm just thinking that question might be the only place where, well, the most common place where enforcement discretion comes up lately is with like software. And there is a guidance document that walks through that I would recommend that the person that asked the question looked at. They should look at that guidance document because it does detail kind of where they draw the line in terms of what's a medical device and what's not. So if it's not a device, they're going to exercise enforcement discretion, then it wouldn't need a 510K in that case.
No, and a 510K exempt device is still a device. So
Correct.
that falls, yeah.
Yes, exactly.
Yeah. So a question to you, Amanda, what actually makes a claim? When is something a claim and when is it not a claim?
Yeah, that's a good question. So FDA views claims as being really broad. So a claim is anything about the product, about its benefits, safety, effectiveness, economics, reimbursement, and it can be in writing, online, in a verbal discussion from anyone that's an agent of the manufacturer. So anything your sales rep is saying about the product would be considered a claim. So that's, it's broad.
And anything on your website really is a claim.
Anything on your website, anything on your, promotional materials, really anything that the company is putting out there into the marketplace, whether it's public or private, really.
Okay. And a question for Bryn, I think if an organization has an MDSAP audited quality system, then that will automatically also apply to the FDA QSR requirements, right? And what will an FDA inspector do if, or will you even see an inspector ever if you have MDSAP?
So yeah, the MDSAP, the FDA recognizes the MDSAP program as appropriate to meet the quality system regulation, but the FDA still has the right to kind of do their own inspections, and the FDA has a slightly different type of inspection process that they follow. But yeah, so you will still see the FDA perhaps even if you are doing MDSAP audits, because they have the right to come in and do their own inspections.
Okay. Thank you. And then maybe a question for Paul. So a HIPAA covered entity, can they be asked to completely delete PHI for a patient or a user? Or
yeah, they certainly can be asked. There's no obligation to delete, so that's not one of the rights given by HIPAA.
Okay. Oh. Thank you. Let's just do one more. I think I can see people are hanging on, so let's do one more question here for Bryn. I think, and the question is, can you be your own US agent through a sub, or is your sub then the importer? If you're a DK-based manufacturer, Denmark-based manufacturer, and create a US sub, is that US sub then automatically importer of whatever you manufacture?
So that's another one where it depends. If they meet the definition of importer, and I don't have it pulled up in front of me, but if they are actually responsible, if that sub is actually responsible for like physically bringing the devices in the country and everything like that, then perhaps yes, you can act as you can have a sub act as your own importer. But it all sort of depends, I guess, on the roles that they're performing with that sub. So.
Okay, thank you. I think that covered the most of the questions, and we are way over time, so I think we have to conclude here, Dave, whether we like it or not.
Oh, Dave, you're on mute.
Dave is frozen.
About that. Okay.
There you go.
I'm an excellent listener when I'm on mute. Thank you for attending, everyone. Again, this recording will be available for in the member section. If you are a guest of Gardner Law, please request a rebroadcast directly from them. Thank you for your presentation today. It was excellent, and I learned a lot, and I think